and thank you for joining us for the final installment of this year's Fall Seminar Series hosted by the Stavros Niarchos Foundation Center for Hellenic Studies at Simon Fraser University. Each year we invite some of the leading scholars working in Hellenic studies to present their research on a wide range of topics including archaeology, classics, Byzantine, Ottoman, and modern Greek history, as well as literary and cultural studies. Before we begin, I would like to take this opportunity to acknowledge that this event was organized at Simon Fraser University on Burnaby Mountain, which is located on the unceded traditional territories of the Squamish, Tsleil-Waututh, Musqueam, and Coquitlam peoples. Before introducing today's presenter, I would like to remind everyone that this webinar is being recorded. If you have any questions or concerns about SFU's Zoom privacy and security guidelines, I would ask you to visit the SFU IT Services website. At the conclusion of the presentation, we will host a Q&A session. Feel free to post your questions in the Q&A box during the presentation, and we will try our best to address them all afterwards. During the Q&A, if you would like to ask a question verbally, please use your raise hand button and our event assistant will unmute you. I am pleased now to present my friend, Dr. Ilias Arnaoutoglou. Ilias is currently Director of Research in the Center for the History of Greek Law at the Academy of Athens. He attained his Bachelor of Laws in Private Law from the Aristotelian University of Thessaloniki and a PhD in Classics from Glasgow University, where he worked with Douglas McDowell, who was the top person in the 20th century working on Greek law in Britain. He was employed as an assistant editor in the Lexicon of Greek Personal Names in Oxford, responsible for Volume 4. He has published several articles on institutional aspects of Greco-Roman associations and commentaries on Greek inscriptions with a judicial interest, as well as on law in the post-Byzantine Greek-speaking lands. And of course, he is also a collaborator with me on a website covering all of ancient Greek law, which is hosted here at SFU, sfu.ca/nomoi. I hope you all enjoyed today's presentation. Now please give a warm welcome to Dr. Ilias Arnaoutoglou.
Thank you very much, David. Thank you very much both for the invitation and the presentation. Okay, so the subject of my talk today is going to be swinging democracy, law in early Hellenistic Athens. The first, I suppose, question one may ask is why swinging? Isn't democracy enough? I think it's not enough, but why swinging? Swinging probably has nothing to do with the 60s and its groovy atmosphere, especially in the UK. An atmosphere liberating especially the youth from every kind of constraints of the earlier decades. More, so you can see the picture on the left. It has to do more with Greece in the 60s, picture on your right, where it was a period of upheaval both in politics and in society. So I understand and I suggest swinging is literally the movement of, it's like the movement of a pendulum, if you like, a movement between restrictions and restorations. And this brings me nicely to the 60 years that shook Athens. You can understand now why I speak about restrictions and restorations. In a period of 60 years, we have at least 6 changes of regimes. The dates are not disputed apart from the one transition in 296 and the one in 287. For both points, I followed the interpretations by Christian Habicht and Michael Osborne. So in this turbulent 60 years long period, Athens and Athenians experienced a strange feeling of changes, especially in politics, roughly every 10 years. And while Athenians experienced that, modern handbooks on Athenian law conclude their discussion with the extermination of the two most prominent orators of the canon, that is Demosthenes and Hyperides, both ferociously anti-Macedonian, in 322 by Antipatros agents. McDowell is the only one to explicitly state that in the title of his book, that the book concerns law in classical Athens. This is finely tuned with the dominant historical approach of the 70s. Although Niarchos continued his logographic activity beyond 322 until at least 307, the death of Demosthenes and Hyperides somehow assumed a powerful significance, signaling both the end of Athenian democracy and the end of a phase in the life of its legal institutions. In what follows then, I aim to challenge both underlying assumptions, that is, one of a rupture in Athenian history in 338 or 322 if you like, and consequently a similar rift in Athenian law, even if the first one has been effectively undermined at least 5 decades ago thanks to the work of Louis Robert and Philippe Gautier and a score of other scholars dealing with the Hellenistic period. The second assumption still marks modern treatments, as you can see in the books by Phillips and Kaparis, modern treatments of Athenian legal institutions. Now, Demosthenes and Hyperides and denotes also the paucity of literary sources available to us. So no more orations on politically inspired graphae, Isangelie, no more cases about commercial disputes or inheritance quarrels. But there is still quite considerable amount of information dispersed in Theophrastos's characters, composed circa 319, in Menander's comedies. Even in the mid-4th century onwards, wills of eminent philosophers, and not only the peripatetic, compiled perhaps in the late Hellenistic period and preserved by Diogenes Laertius in the 3rd century AD, on the basis probably of an earlier biographic tradition. And some Plutarchian lives of statesmen and kings, as well as comic fragments of New Comedy especially, may also be exploited in the same manner. However, major source for the legal institutions of the period in discussion remains the hundreds of decisions inscribed on stone slabs by the polis and its constituent parts, demes, tribes, etc., private associations and individuals. That this record is skewed in the sense that it preserves an official, partial version of how institutions were interweaved and operating, but it ignores the everyday realities of, say, the administration of justice, is a deficiency that we have to live with. My fundamental consideration is based on the notion of continuity. Continuity is to be understood not as a slavish repetition of norms and practices. And we were interrupted at the moment when I was saying that the Athenian legal system was based on a series of interlocking arrangements reached through consensus in the assembly, the council, and confirmed in the law courts. Its fundamental features included full citizen participation in deliberation, executive and the justice administration, iteration in magistracies, and strict accountability. For assessing the situation in post-322 Athens, I will use the traditional division of law into public, private, and procedural. From the outset, I should make clear, of course, that the changing international landscape impacted mostly and most severely on public law. Now, I will start with the private law. Private law remained largely immune to outside foreign pressure to come into line with the Macedonian dicta, largely because Macedonians were not bothered to do so. In this way, major private law institutions operated as usual. For example, the exploitation of public lands and the civil mines in Lavrion continued as before. As inscriptions unfortunately fragmented, this was the previous slide, from the Athenian Agora excavations testify. Dim leases, as you see in that, this is the one I told you about, the public land and mines leasing. You can see that one is dated to 3076 and a late one in 28180. And of course, there are several that they are dated at the edge between 4th and 3rd century. Demes leased their lands and other assets. Private cult associations did the same too. Here you can see the evidence and the fundamental study by Nikos Papazarkadas. Land was offered as security for loans, dowries, and leasing an orphan's property, something that suggests that these institutions remained unaltered. As the next slide, you will see the evidence. Now, the evidence for a particularly Greek inheritance law institution, the Epikleros daughter, is amply attested in a new comedy, and not only in Menander, thanks to the ambiguities and the tensions in social life it created. That it continued well beyond the new comedy is attested by the inscription you will see on the next slide, an early 3rd century honorary decree of the tribe Erechtheis for Antisthenes, son of Nicandros of Lamtre, whose daughter is called a lawful Epikleros, lawfully became sole heiress in the inscription. The philosopher's testaments I have mentioned before provide useful evidence about the use of endowments and the status of its recipients. Now, the administration of justice was affected only indirectly. In particular, it was only the number of citizens qualified for dicastic service that was fluctuating, but this cannot substantiate later claims that rhetorical contests, as reported in Suda, were annulled. Even the claim about the disappearance of public arbitrators in post-322 period should be regarded as unsubstantiated, since it relies on an argument a silentio, and the paucity of honorary inscriptions can be explained without assuming a radical intervention. Citizens' participation in the courts was fluctuating, as I said, leading probably to a reduced number of dicastic panels. That is, there were less panels available of 251 dicastae hearing cases, but that would have led perhaps to more sessions for them, or simply wider use of alternative dispute resolution procedures, something that has never disappeared from the Athenian system of justice administration. There is no evidence for the introduction of a new legal procedure, although some of the existing, politically sensitive, may have been left to fall in disuse, but not in oblivion. Finally, the most susceptible to foreign-induced intervention, in political theory they are called
exogenous change was constitutional and administrative law. In this area, and for the period 322 to 262, we can distinguish two major modes of intervention. The earliest, and I suggest the harshest, was to attack one of the cornerstones of Athenian constitution, that of citizenship. From 322 to 319, a property threshold was introduced, a measure that led, according to some authors, to 12,000 or, according to some other, 22,000 Athenians to lose their political rights. That is, the right to participate in the assembly, be a member in the council, and participate in the law courts. That is exactly, that's how they're described by Diodorus of Sicily. Probably in this spirit, a consolidation or merge of some magistracies was required and duly took place, as the case of Astinomi, is the next slide, whose jurisdiction was subsumed into that of agoranomoi. Perhaps that happened on a larger scale, affecting a number of minor magistracies too. The ascension to prominence of a lower secretarial office, this is what you can see here, the expression prostetactai tois agoranomoi is the key phrase. The secretarial office, that of anagraphers, is usually interpreted as an oligarchic element, but such an interpretation disregards the simultaneous reform of the council's secretary term in office from a year-long service to a monthly rotating one. You can see it's illustrated, this is illustrated in the next slide. And also the need to have a person to coordinate the secretarial activities. You can see here that what I said about the monthly long service and not a year-long one, we have a decree, two decrees of 320/19, that in the second prytany there is Thyramenis as a secretary, while in the fifth there is Nicodemos as acting as a secretary. Another reason for this change, I believe, is that if they change the term in office, they would need somebody to coordinate the secretarial activities, and this role was entrusted to an anagraphers. Furthermore, the reform indicates a return to the mode of appointment that was current in the 360s, that was still a democratic period. As soon as the military support for the pro-Antipater regime was reduced or withdrawn, it collapsed under the pressure of the still operating Macedonian faction led by Hagnonides and those disenfranchised. The return to the pre-322 regime is marked symbolically by the relegation of anagraphers for the remaining months of 319/18, and this is the next slide, in the second place behind the eponymous Archon. And here you can see that to the left, you have the anagraphers who comes on top, while, and here you are in the fourth prytany of the year, while in the seventh prytany of the year, it's about 3 months later, anagraphers is relegated behind the Archon and the secretary. Now, the return to the pre-322 regime is marked symbolically by the relegation of anagraphers, as we can see, and by the employment of an eisaggelia against the leading personality of the regime, Photion, and his followers. They were prosecuted for treason and overthrow of democracy. Following a year, roughly, of restored democracy, another oligarchic regime, in inverted commas if you like, oligarchic, that of Demetrios of Phaleron, followed largely the same path, again to use a slang from the political theory, a path-dependent reform, introduced a less drastic citizenship restriction, but a more focused intervention. The amount of property threshold was halved, but a supervising authority was instituted in order to oversee the proceedings of the council and of the assembly. You can have the next slide. These officials, this authority, were called Nomophylakes. Most of the remaining reforms that are ascribed by historians to Demetrios of Phaleron, and you can see the account in the book by Banfi, are of doubtful authorship, result of misunderstanding, ancient and new. The second mode of interference in Polish administration is one that pays lip services to the autonomy and self-determination, but undercuts that with the establishment in position of control of a group of individuals devoted to the interfering power. If change in public law institutions were exogenous, the return to the pre-322 democracy was also foreign induced. Both in 307 and 287, it was the Antigonids and the Ptolemies respectively who threw their weight to the side of the democratic faction. This resulted, at least in 307, to a fundamental change in the fabric of the Athenian administration. By adding 2 more tribes to the traditional 10, the Democrats increased the number of magistrates appointed on a tribal basis. This was partly a response to the contraction of the body politic I mentioned just before, implemented a decade ago. Therefore, the number of the councillors now rose from 500 to 600. This meant an increased chance of the ordinary Athenians to be allotted in the magistracy or in the council. However, it also meant that many more proposals for decrees were more likely to be discussed in the council and less to be introduced by the initiative of an assembly goer, especially if the number of the assemblies were reduced from 4 to 3, something that I'm not sure, but there is a tradition that there was such a reduction. There is also evidence for tightening the rules on the award of crowns. For example, from 304 onwards, the price of the crown is not mentioned in the decrees, only its lawful award. And there is another clause appearing at the same time that the grant of the crown is going to be done only when the process of Athens was completed. Most probably, there were some tightening of the rules and change of the rules concerning the award of citizenship with the introduction of a law court scrutiny of the award. At the level of narratives, there is a continued invocation of democratic practices like the one mentioned in the honorary decree for Eucharis. You can see the next slide. This is the traditional democratic reference of the proposed laws that they should be displayed in order to be available for close scrutiny by anyone wishing to do so that nobody will claim to ignore the laws of the city. This becomes even more evident in the last period, the last 25 years, from 287 to 262 regime, when the term democracy of all Athenians was coined by the Democrats. So we have an eventful, cursory account of the 60 years period that shook Athenian law. What emerges from this account, I think, is the resilience, the tenacity, and the strength of the democratic legal institutions and principles. We saw that in the realm of private law, nothing was affected, no major changes occurred. The administration of justice, due to its structural elasticity, coped with the reduction in the citizen number, when such a policy, of course, was implemented. public law institutions branded the full impact of the shifting position of the polis in the constellation of successor politics. Although the impetus for institutional changes was exogenous in origin, these were planned and put to work by Athenians. And if we can go back to the third slide, you can see there that every change usually it's associated, there is a leading Athenian associated with it. So these Athenians were those who translated commands out of treaties with Macedonian monarchs, and they turned these commands into political norms and practices. This proves, in my opinion, that at least some kings were not a priori inimical to democracies, but they were rather cynical in exploiting every opportunity to further their interests and their realm. As we have seen, Athens between 338 and 262, and perhaps further down to 229, lived through her Macedonian century. The upheavals of the period taught Athenians how to play out Alexander's successors and Hellenistic kings against each other so as to preserve their independence. The above investigation suggests that there was no significant change in the overall picture of Athenian law, but only foreign-induced reforms for a limited time and certain areas only. The law of Athens continued to operate largely unscathed. The implications of that observation is twofold. First, we cannot establish a red line to separate classical from Hellenistic in Athenian law. The legal and more generally the normative framework of Athenian society remained almost intact. And second, further research and study of Athenian law should not exclude the period 322 at least to 262, but it should try to integrate it in the narrative about Athenian law and society. Thank you very much, and I'm deeply sorry for the interruption.
Ilias, thank you very much.
Yes. You're welcome.
You took us into an area of Athenian law that is beyond those of us who stop at 323, and showed us that these continuities can be used successfully so that we should actually feel more at home delving into these issues. Maybe I could ask a question or two before others offer some of their questions. I'm wondering, you talked about the limiting of the participation in the law courts based on the property qualification.
Yeah.
And I wondered whether you've given any thought to the extent to which this emulated limitations on the democracy that go right back to the end of the 5th century, and so that we could surmise on that basis that there actually had been a continuous stream of anti-democratic, oligarchic ideas that continued through the 4th century until these changes were made in the Hellenistic period. Have you given some, I mean, your concentration was on the survival of the democratic, and I'm wondering about parsing out a little bit more of the anti-democratic and where that comes from.
Yes, that's true. There is what they call the anti-democratic thinking, but I'm quite skeptical whether the reforms were as strict as those imposed by the 30 tyrants in the late 5th century. If I remember the numbers well, they reduced the citizen numbers down to something like 5,000 or even less, while with the regime imposed by Antipater it was just 9,000 left. So you have a much milder situation. One of the leading figures of the regime actually that negotiated with Antipater and was encumbered to implement the agreement was Phocion, who was notorious for his a Spartan-inspired way of life. But still he was elected general in Athens for several decades. So there is a current of anti-democratic thinking going on. Sometimes, you know, they detected in some of Isocrates' writings. But I'm very skeptical about whether this anti-democratic thinking was really in the back of their mind, or it was the bare necessities of complying with the Macedonian army demands that was outside Athens.
Great, thank you. I had occasion recently to work on the pseudo-Aristotelian problems. Book 28 deals with legal issues, but lacking the experience with Hellenistic law, I wasn't really asking myself about the extent to which this could have been the product of a Hellenistic thinker, since it was really only the question of, is it Aristotle or not? I wonder, do the people who, like yourself, interest themselves in these questions look to that text at all?
Only fleetingly. I haven't really read it properly. Only fleetingly I have consulted, but to tell you the truth, I wouldn't expect too much change from all the problematic, all the thinking that was going on in the Lycion. The people who composed most of the work in the Aristotelian school were just living the experience of participating or listening about Athenian politics. So I'm very reluctant to put a draw line between Hellenistic and classical in that period, in that era. I have the impression that the people were inspired by what was going on, what they could see in the assembly, what they have learned that was going on in the council.
Good, thank you. I noticed in one of your slides you referenced a paper by Nomophylakes
Yes.
on Theophrastus' characters. And
Yes.
do you know offhand of an example from the characters that informs these questions at all?
The best known, and it's topical in the sense that it comes back to your first question, is the character of the oligarch. So there is a character, I think it's number 19 or something like that, that Theophrastus describes what an oligarch looked like in Athens. And it's perhaps the most rich source we have about the movements of a person who appeared to be a supporter of the oligarchy. For example, his opposition to the triarchy and things like that. But the characters are full of, it's not only the oligarch, because there are a lot of references, you know, to the everyday legal contracts and the legal relationship in there. It's just under the surface, under the description. Loans, for example, some of the Aranoi appear there, these what we call friendly loans appear in that part, in the characters, as well as useful information about the legal climate, the legal atmosphere. Of course, the problem with characters is that we don't know exactly when it was composed. So we assume, because there is a reference to Cassander, that it was around 320. So it's definitely the last quarter of the 4th century.
Yes, certainly.
Yeah.
And also what we know about when Theophrastus lived.
Mhm.
I'm not actually seeing any questions submitted here. And I'm wondering, oh, no, we touched on that one. I think I myself and many others would find the PowerPoint presentation itself, the slides and their bibliography to be of great use. Is there a way that you can make that available? Would you mind that we share it with the participants in this symposium?
Yeah, no problem.
Thank you.
No problem. Had I knew that earlier, I could have made it even richer. But anyway, I think I will gladly just do that.
Uh-huh. Well, you and I were talking earlier about the possibility of extending the Nomoi project into the Hellenistic period, and there the hope is that we will have the opportunity to give a much more expansive bibliography of Hellenistic law in that context.
Mm-hmm. Yeah, yes, I would like to see that, because the more I work with the Athenian case, the more I realize that, at least for Athens, the adjective Hellenistic is not really pertinent. I would say Hellenistic for the word outside Athens, because in Athens, very few things change. I mean, recalling now what new these regimes might actually brought, was just very little that survived. What survived was the tenacity of the democratic principles. It's the democratic principles of accountability, of iteration, even if, for a moment in 294, 93, even this was violated once, actually, we would say. So at least for Athens, there is a lot of sense in going back. I would rather go down to the coming of the Romans. Definitely I will go to the end of the 3rd century. So now I can see that there are a couple of questions that do I have to answer? Should I answer them, or may I answer the questions?
Let me pose the questions orally.
Yeah.
From Alexander Jovanovich. Thank you for the content of rich talk. It was generally insightful. I have a question about the ways in which this political swinging was performed in public spaces around public Hellenistic Athens. You have mentioned the international influence on the Athenian law at the beginning of your talk. So do we see any, however tangential, influences of Roman legal practices in the 2nd century vis-a-vis Ptolemaic and Antigonid ones, as we see them in the architecture of public spaces in Athens and other Greek polis, with the erection of Roman rostra like bema by the Straw of Attalus in the 2nd century?
So it's difficult. It's difficult really to say something, because I haven't studied really properly the 2nd century. But the Ptolemaic and the Antigonid influence was just on the level of striking an alliance just to counter, in the first case, Cassander, in the 2nd case, the Antigonids. So it was just like a game of politics, of power politics. I don't, of course, in the late 3rd century, especially after 229, you had some more, a very strong building activity with the Ptolemaion and the Gymnasium in Athens and so on. But I'm not sure about whether the Romans so early exercised such an influence. I think we have to wait for the Augustus and so on, after the Augustan era, to see the result of an influence. So the second question is?
Yeah, I'm seeing now that people are typing longer questions, and that was the reason for the delay. From Andreas Augusti, thank you for the presentation. Like myself, I am out of my context zone after 323. I wonder if you could articulate it a little more explicitly the stakes of your conclusion that we should see continuity between classical and Hellenistic Greece. As a political theorist, I get the feeling that the boundaries of classical Greece as a democracy are policed by scholars like Ober and others who want to talk about the rise and fall of the democracy. Are folks like Ober wrong?
I don't know how daring it is to say that they are wrong, but I wouldn't agree that there is a fall of democracy in 338 or 322. You have to go and read the decrees in, say, after 307. You have to see the reforms that even if you consider factional politics in 307, even the factional democratic function tries to deepen, in a sense, the democracy they have inherited, or the democracy they remembered that was apparently abolished for 10 years. So they bring in reforms, they try to tighten the rules, to make clear in other cases rules. But in the back of their mind, they have still the democracy of the era of Demosthenes. And this goes on very well down in the 3rd century. It goes down to 262. So I would be very, very hesitant to say that there is a fall of democracy in one form or in another. I know that Paul Cartledge claims more or less the same things in his recent book. So he dismisses all the period after 322. But I insist that this is not the case. We have people who remember, who have experiences how democracy before 322 worked, and they seem to be determined to put it to work again in 307. So I hope this is this is helpful.
Yeah, that's wonderful. Thank you. From Domingo Aviles, first he wasn't aware that our Nomoi bibliography didn't extend to Hellenistic law, so we seem to have kept that a good secret, right? But is there another source of specific bibliography for Hellenistic law that exists at the moment?
No. So far, Hellenistic law, the tools we have for Hellenistic law is confined to the Bulletin Papyrologique, where you can get in the database and type some terms so that it will produce you, entries concerning especially papyri and studies on papyri about these institutions. So effectively, we have an old, in the 60s, short bibliographical notice that Melez Modrzejewski has produced in Brussels, which is roughly 50, 60 pages long, and it has only the major references to the Hellenistic period.
Great, thank you. From Adele Scafuro. Hi, Adele. Thank you, Ilias.
Hi, Adele.
Adding in archaeological evidence, the Cleroteria, for instance. And do you know anything about that final court building that Rise Townsend presents? It wasn't finished, apparently, which suggests what?
Yes. Hello, Adele, from me as well. About the Cleroteria, I couldn't cover all the kind of evidence that there is about the functioning of democracy, because apart from the cleroteria that were found in the agora, there were found pebbles that they used to vote in the courts, something that suggests that the courts were operating as well. About the unfinished building, it might be left due to financial difficulties, due to some of the sieges that Athens suffered in 296, 297, 296 by Demetrios Poliorkitis. That's what I can think of.
Well, we have a nice segue from Sergio Basso after a question from Adele, who's written lots on on comedy. After thanks, he's asking, would you spend some more words on Nea Commodia as a source for Hellenistic legislation? Theater and comedy could have twisted some details of a law for dramaturgical purposes, comic effect, for instance, and as in many cases, due to the fragmentary nature of the sources, we lack the context, and we might not get the comic distortion.
Yes, thanks for this question. The new comedy effectively is one name, is Menander. That's what is preserved. Although the preservation, you know very well, is through papyri, which are extremely fragmented, and they have to be very carefully and thoroughly reconstructed. Menander, I think people like Adele Scafuro and others who wrote on the period. So the information that we got from Menander is largely concerning institutions of private law that we use it for reconstructing what was going on in the classical period. So in a sense, Menander really comes to my aid concerning the reconstruction we have about Athenian marriage, the reconstruction we have about the process of arbitration, private arbitration, and the reconstruction of what we know about the ambiguity and the tensions that the Epicleros daughter was creating in Athenian society. Unfortunately, we have only Menander. The scraps we have from the other comedy writers, they are dealing either with Epicleros. We have something like 10 or 15 titles of comedies called Epicleros, and the other passage I could find topical is a passage from Alexis, who refers to the although implicitly to the removal to the restrictions imposed on philosophers, but I couldn't find anything more than that in the new comedy. Perhaps the investigation that Scafuro led in her book on forensic stage and law, trying to find out whether the plots that they are adopted by the Latin comedy is worth pursuing even more. But I definitely, the new comedy is all we have is Menander. Okay,
Right.
that's all.
Yeah, thank you very much. I think we actually have managed to exhaust all the questions, and it is now, well, it's not, for a Greek, it's not that late in the evening.
No.
But it's time to wrap things up, I think. This has been wonderful, Ilias. You really changed my thinking about the continuities of law from classical to Hellenistic Athens, and given me more courage to delve into these issues more. So this has really been life-changing for me in some ways. Although, of course, in a fairly arcane area, as most people would suppose. So I guess we'll wrap things up with many thanks from us, and I'll look forward to being in touch very soon.
Okay, thank you very much for having me and for listening despite this mishap, you know, what I think, and I hope that soon I will have it ready for publication.
Wonderful.
Anyway, thank you very much. Okay, see you soon then.
Bye for now.
Bye-bye. Bye.